We've been talking student loans for years.
Yes.
On this new guidance from the Department of Justice and why it's so effective for bankruptcy attorneys to make money. First of all, why don't more bankruptcy attorneys do this? What's the holdup?
I think there's a lot of things that work here. I think first, for 20 years, people have believed that you can't discharge student loans in bankruptcy. That's been a challenge. There's been obviously some political change. People haven't been sure whether or not the guidance would continue. And I also think that there have been a lot of pauses with respect to repayments of student loans. So a lot of debtors haven't necessarily been motivated to look for solutions and pay for solutions. According to a letter from Elizabeth Warren's office, as well as a couple of other senators at the end of 2024, which is the latest figures we have, about 85% of cases have received some sort of discharge, with 70% getting a full discharge and 15% getting a partial discharge, which is huge because previous to that, they estimated that it was something like 0.1%. So we're literally talking like, almost 1,000% increase on the number of cases that are getting discharged.
And this is because now debtor attorneys have an option. They know exactly what to submit. There's no guesswork. Here are the most important things in order to get a student loan discharge.
Right. I mean, what would really happen, Philip, is that when the guidance came out, they didn't change the underlying statute. They obviously had no power to do that. Same thing with the case law. They didn't really change the case law. But what they did is they took the statute and all the case law and all the cases that have happened over the years, and the DOJ, in conjunction with the Department of Education, came up with guidance that basically created objective standards that people now know and they can follow, so that they have the playbook and they know how to achieve a discharge. And also, I think there's been a shift in thinking at the Department of Justice, rather than trying to, quote unquote, win every single case that was brought, which meant that you would deny the adversary proceeding and not discharge the student loans. Now, a lot of the focus is on trying to help and determine whether or not the guidance has been met and those objective standards have been met, which makes it a lot easier. I mean, we have their playbook. They're following that playbook, and it's just a matter of trying to see whether or not you can get your client through that process.
Debtor attorneys were worried that it's going to change under the Trump administration. What are you seeing on that?
So we know that that's not happened. We know that they're continuing to proceed with these cases. I think it's important to understand that this process has its roots in a 2018 RFI. Folks will remember that that was the Trump's first administration. So they issued an RFI specifically looking how to better define undue hardship. Hundreds of people responded, including folks at NACPA and others. So unfortunately, they didn't finish anything during that first administration, and it was the Biden administration in 2022 that then went through and published the guidance. Now, when the second Trump administration took office, a lot of people were concerned that it would be changed. The reality of it is they took a look at it. I've spoken to a couple of the AUSAs who confirm that they have been told that they can proceed with this process. And I think in what's probably the most telling sign that they intend to proceed with this is they recently updated the form, the attestation form, and they updated the website on the DOJ guidance page. It's hard to imagine that they would do that if they weren't supportive of the process.
Now, there's a handful of things that debtor attorneys need to look at to see if this is a good case. Give me the handful of things, the 3, 4, 5 things that are the most important.
Right. Well, it's still, it's more or less tracking the Brunner standard. And so the first test is whether or not they can presently afford. And that basically has now become really a math equation. You just need to know what numbers to add up. And expenses obviously have to exceed income for that purpose in order to pass that test. But it's a lot more liberal. For example, they're now looking at a standard repayment plan of the student loans rather than getting on an IDR. That makes it usually a little bit more expensive, if not a lot more expensive, and thus less affordable. So it's a lot easier to pass that first test. The other things to look for, if you have older clients, that almost always allows them to pass the second prong of the test, which is future ability to pay. Also, another thing to look for is if someone has their loans in repayment for more than 10 years. Okay, that's not typically like a loose thing that we would look at is when did someone graduate? If they graduated more than 10 years ago, chances are their loans probably went into repayment shortly thereafter. So that's something that you can look to. Another thing you can look to is if someone has some sort of a disability, right? And the disability isn't the same standard as total and permanent disability discharge, which is obviously a much higher standard and a different type of a discharge. This is really anything that affects someone's ability to work. So, the guidance just basically takes more information. It's a little bit more realistic. And rather than making it nearly impossible, it really makes it a lot more realistic for a lot more debtors to achieve discharge.
What are debtor attorneys charging for this service? Just the range, because I know it's all over the place.
It's exactly right. It's all over the place. It varies from $2,500 to $7,500 and everywhere in between. And attorneys are approaching it differently. Everyone's got a slightly different business model. And so they're doing whatever works for them. I will tell you that the Northern District of California passed a no-look fee, and that's $4,500 for this process. So that will give you a sense of what the courts are looking at as to what they're saying is reasonable right off the bat.
So Igor, your software that you helped develop, right?
Right.
Helps attorneys decide if this is an adversary they should file or not.
So at Stretto, we've developed what we call the discharge analyzer. We've also developed what we call the discharge snapshot. And our goal here is, even though the process under the guidance is more objective and a little bit easier to track and follow, there's still some work to be done. You have to look up IRS standards. You have to know all the factors. You have to know how everything fits in together. And so there are still, some work to be done if you're doing this on your own. So what we've done is we've tried to develop a suite of services that help debtors' attorneys determine whether or not this is a good case to even start, and then help them finalize the case. So our discharge snapshot, for example, Philip, it allows our attorneys in under 2 minutes to answer a handful of questions, about 10 to 12 questions, depending on the circumstances. And then in less than 2 minutes, you're going to know whether or not your client has a relatively decent case to move forward. So that's a great way to start. The snapshot is entirely free. It's something that we offer to our clients so that they can quickly assess their cases. Like I said, there's no cost to it. If they want to proceed, they'll move on to what we call our discharge analyzer. And our discharge analyzer does a real in-depth dive into the analysis of whether or not your client is eligible for a discharge. And that we charge $29 for our report. And that basically gives you a very thorough review as to whether or not your client appears to satisfy the guidance requirements. It takes about 30 to 45 minutes to complete. We integrate with the NSLDS file, which for those that don't know, you get from the government, and it's your client's full history of their loans, the types of loans, what they've gotten, when they've gotten it, et cetera. It helps us use the same exact information that the federal government's using in making their assessment. And so at the end of doing this process for $29, you're going to get a complete assessment of all of the standards under the guidance, and you'll have a pretty good idea as to whether or not your client appears to be eligible for a discharge and why, right? And so if, for example, they may not be eligible, you'll understand what circumstances that exist in their case that they haven't met. That will give you the ability maybe to go back, tweak some of their cases, case information, or maybe take, not necessarily do the discharge now, but maybe come back later. And then if you do the report, if you want to proceed, for $99, we give you a full attestation package, which means that we give you a fully populated and completed attestation document, so you don't have to complete it yourself. It's what the Department of Justice uses as its central document to analyze the case. We also give you a draft adversary complaint, something to start out with, because we know a lot of bankruptcy attorneys don't necessarily love filing complaints. So we give you something to start with. And lastly, we give you a supporting document checklist. So based on the information that you've provided during your analysis, we're going to let you know the documentation outside of the attestation that you should submit to the AUSA that will support your application.
At the lot for $124.
128, but yes.
120 at the lot for $128.
Yes.
Igor, what percentage, when your software gives them the thumbs up, like, yes, this is a good case, and yes, here's the attestation. What percentage of those that are submitted, do you have any numbers on what those submitted actually get a full or partial discharge?
Yeah, so unfortunately, we don't have a full tracking and visibility because it gets filed and not everybody reports the results back to us. But I can tell you that our success rates are at least the 85% that you're hearing from the federal government and then some, because again, our clients know which cases to avoid. We help them understand that. We also help them make sure they know how to support those cases. So we've been, very successful. And I can tell you anecdotally, we get a lot of calls and a lot of emails from our clients who just, are surprised as to how well their debtor clients have done. We've had a number of cases where more than $500,000 have been discharged for a single client, which is great to hear because it literally changes people's lives.
Yeah. Well, and not only that is if they charge the minimum $2,500, because that's sort of what I hear too. They charge around the minimum I hear is $2,500. That's the equivalent of another bankruptcy.
Absolutely. It is a great opportunity to continue to work with the clients that you have, offer better services, and at the same time, make a little bit of money. I mean, one of the things that I'm most proud about what we've done is that this is a great opportunity for bankruptcy attorneys to expand their practice, but at the same time, you're really doing great things for your clients. And as things change and now people are going to have to start paying their student loans and collection activities have started, wage garnishments are going to begin if they haven't already. The reality of it is, people are stuck. Debtors have really very few options. And we have the opportunity to really do some very good things for them. And at the same time, continue to improve our businesses in the process.
Well, and at one NACPA, I believe it was NACPA 2024, one of the speakers said attorneys now have a fiduciary responsibility to even approach it and ask the question. Speaking to that, Igor.
Right. I think that's right. I think, as a bankruptcy attorney who's responsible for reviewing a debtor's case, it's hard to see how you can be justified in overlooking, what's typically the second largest consumer debt for most people, and that's their student loans, only behind mortgages, right? So if there's an opportunity to discharge those student loans and you don't even have a conversation or make them aware of it, I think you have to be careful with that. I think that there is, some responsibility to at least make your clients aware of that. I think earlier, before the guidance, when most people weren't successful, I think attorneys gave proper advice when they said that there's not much you can do with, student loans and bankruptcy, because that was accurate. I think now with this discharge process and also the ability to help enroll your clients in IDRs, income-driven repayment plans, it's really incumbent on attorneys to offer, at least to have the conversation and be a little bit more aware of what the options are. Even if it's not something that they're going to do themselves, they should be aware of it and be able to help point their clients in the right direction. Otherwise, they may be coming out of a bankruptcy and lose the opportunity to discharge loans because it's certainly not anything you can do outside of bankruptcy.
Why do you think attorneys, because we hear it all the time, the debtors come to us and say, my attorney didn't bring this up? Is it because of just not knowing or not wanting to focus on it? Why do you think that's the case?
I think everyone's, there's a lot of different reasons from a lot of different attorneys, depending on how everyone runs their practice. I think it is very challenging. Last 5 years, filings have been down. Attorneys have been, trying to manage their businesses as best they can. It's a relatively easy process, but it's still something that you have to incorporate into your practice. And so it takes a little bit of time. It takes, like anything else that you learn new, it takes a little bit of time. It can be a little frightening at first, especially when the last 20 years, people have generally believed that you can't discharge student loans. So it's very hard to change that mindset all of a sudden. And again, because for the last 5 years, student loans have basically been on hold, there hasn't been a lot of pressure from clients to do stuff with it anyway. So I think there's a bunch of different circumstances that come into play, but I think that's changing just based on the conversations that we hear, based on the interest that we're seeing from all of our bankruptcy attorneys. I think the tide is changing, and I think you're going to start seeing a very different approach to student loans in the next year. People can go to dmmportal.com, dmmportal.com, D as in David, M as in Mary, M as in Mary, portal.com, and you can log in from there and access our tools.